on to our next panel discussion. The topic is Modern World of Litigation, Knowing, Preparing and Presenting. Please welcome our session moderator, Mr. Tushar Agarwal, advocate on record with Supreme Court of India. Please give him a big hand, ladies and gentlemen. Our second panelist for this session is Mr. Balakrishna Gopalakrishnan, founder of BGK Law Associates. We can take a coffee break, ladies and gentlemen, if we need some energy, but please give them a big hand. Please welcome our next speaker, Mr. Chanchal Choudhary, Managing Partner at XpressLegal. Lastly, but mainly, please welcome Mr. Adam Maniam, Director, Dispute Resolution at Drew and Napier, LLC.
Yeah, good morning, everyone. So the panel of four, we have I am Advocate Tushar Agarwal, practicing lawyer in Supreme Court, New Delhi. With me, my co-panelists are Mr. Balakrishna Gopalakrishnan, founder at BGK Law Associates, Mr. Chanchal Choudhary, managing partner at XpressLegal, and Mr. Adam Maniam, Director, Dispute Resolution at Drew and Napier, LLC. So our endeavor is the topic for the panel is discussion is Modern World of Litigation, Knowing, Preparing and Presenting. So the entire discussion would be revolving around in the post-COVID era, the kind of digital transformation of litigation especially, and how the Indian courts had adopted digitalization and what are the pros and cons of those digitalization. So the Indian part will be covered by Mr. Balakrishnan, me, and Mr. Chanchal Choudhary, and Mr. Adam would be highlighting about the part of the Singapore, how Singapore Singapore courts have adopted the modern technologies of litigation. So if I start with Mr. Balakrishnan, so sir, as you see in the COVID era, mostly in India, litigation was all about physical presence, going to the courts and presenting yourself before the courts. So in the post-COVID era, what is your opinion about the important role being played by technology?
Yeah, I think that's a good question. So before I answer, I have to take you back to what was there in pre-COVID era. And I would put a disclaimer that even after the COVID era is over, or now it is waning down, and it says Mumbai has only 580 cases per day, so that's something very heartening for us. But still, I feel a tendency for the court to go back to the old way. That should be curbed. That is my one particular issue. So what happens is in the earlier era, when I started the practice, when I started the practice and when I went to the court, you are known by how many briefs you have and how much of tons of paper you carry, the books, and you keep all the books on the table, and when you go there, your court clerk puts a lot of books, and he carries a bag with all kinds of AAR, and at the time it was AAR and SCC and all those things. That means look, this lawyer is very good, and he is going to have a big case, and so much of books he is going to present, and so much of case laws he is going to present, and therefore it is going to take some time. And so the others look at, oh my God, he's such a man, and he has spent a lot of time studying all these things, and so that was going on. And especially I think for a later time when I went to the Bombay High Court, pre-COVID times also, half of the area will be covered with these bags, and which have the names of each of the firms, and who is representing, or that is there. But suddenly on March 17th, our Prime Minister said that we are going to have a lockdown. And it was in 2020, March 17th, it was told. So we took it very lightly, what is going to happen. It may be for a week or two, like, you have a, you have a fever, and, it goes within a few days, and, it's like that. But the transformation which took place for the courts was sudden, very wonderful. I never thought that the court was able to convert itself into a digital transformation by allowing us to appear from our comfort zone of comfort, where you are sitting in your home, or where you are sitting anywhere, you can address the court and get it done. And there are funny stories also when you're sitting at home. Many senior advocates were sitting in shorts, and and then that also was there. I'm not denying the fact, but now everything, yesterday we were talking about data privacy, but there is nothing private. Even if I sit here and do something, that will be known to my people there, within 2 minutes or 2 seconds. So that gave me a lot of, because, see, my education was completed when, it was not a era when I carried a laptop to the college, or an iPad to the college, or a mobile phone to the college, So today, for me, it is something great, it gives me a lot of comfort, and that's it, so I can attend this conference and still I can work. I mean, yesterday I was answering to many things, and yesterday also in the comfort of my hotel room I was having a discussion on a matter which is litigation, which is going to come up in December. So the transformation of Indian courts into the digital era, or digital transformation, is something wonderful. It is all kudos to all the judges, and many of them may not have, many of them may be categorized in my category because they may not have gone to the school and college with laptops and iPads and iPhones. But that is something great, and I'm sure that it also gives an edge to the young lawyers. So young lawyers can sit, instead of going and standing in the court and getting nervous, they can sit in their comfort and, and have a hot cup of coffee or tea and still, present their case, because their nervousness will not be known to the court, and the court will not ask you, calm down, say, did you not study the case? Or, like an open book exam, they can look at this and, read out, or somebody can prompt them. Because I've seen prompting, I've seen somebody prompting them, or maybe the court clerk or a junior, whatever it is. So I think the transformation which happened is a wonderful thing, and it's something great as far as the Indian judiciary is concerned.
Yes. So for this, as from Indian courts, I would like to ask the inputs of Mr. Adam, if he can also tell about the digitalization of Singapore courts. Is it the new thing post-COVID, or since many digital tools were already available before COVID era also?
I think many digital tools were available before COVID, but the status quo, the norm was that you will always go to court. There will always be a physical hearing. And then on 7th of April 2020, Singapore similarly had a lockdown, and all the litigators were wondering, what do we do? How do we go to court? How are we going to argue cases? But I think similar to the Indian courts, the Singapore courts adapted very quickly. Hearings were conducted by Zoom very quickly after the lockdown was imposed. And this was actually critical for clients. So I had a case that came in during the pandemic. A client needed an injunction to stop a licensing agreement from being terminated, a $50 million licensing agreement. And the client said, look, I need to somehow have a hearing. I need to get these orders, because if I don't, the other side is going to terminate, and that's going to be hugely problematic for us. So because of the technology that was available then, I mean, this was arbitration, but still we managed to file the application. We got a hearing within a couple of days. It was a virtual hearing with lawyers from Singapore, Malaysia, an arbitrator in Hong Kong, and the hearing was done. We got the orders, and just a couple of years earlier, that would have been something quite unlikely, because previously for arbitrations, even the procedural hearings, if you don't have it physically, it'll be by telephone. You don't have virtual hearings just a few years earlier. And I think another area where technology has become important, it's actually caused there's actually a problem that's caused by technology, and that's really the proliferation of information. 20 years ago, if you have a lawsuit, there would be contracts, there would be letters, and those would mainly be the documents. 15 years ago, you would have contracts, letters, and some emails. Nowadays, for any dispute, you have contracts, letters, emails, WhatsApp chats, Telegram, WeChat. Every case, even if it's not particularly high value, you could easily have tens of thousands of documents. So one area, I mean, that's a problem created by technology, but similarly, technology, we have various tools which now help us to deal with this increase the amount of documentation. So that's my take from the Singapore perspective.
Thank you. In this, regarding the tools, I would also like to add something, the tools which are helping us in the preparation and which have become necessary for every lawyer being a litigation lawyer or a firm, or maybe in a big setup like firms, mostly some digital tools are already available. But in India, private chamber practice quite prevalent. So those people post-COVID era were not using that much technological tools. So for us, litigation lawyers like us, the important tool of, for example, legal drafting tools. If some kind of samples or there are technological companies which are providing, or legal portals which are providing drafting facilities. So yes, if we have to file e-filing softwares, we need to be well versed with. So that's the area where we need to be compulsorily, because Delhi High Court and some other courts and everyone, they are doing compulsory e-filings. And also about the organization of your documents. Since as Mr. Balakrishnan mentioned that earlier the lawyers used to be known by how much bulky brief they are taking. But nowadays, even the senior counsels and the counsels like us are arguing from the iPads and laptops, where the documents are very well organized along with the highlighted part, bookmarkings and everything. So the organization of documents, so even the technology has made it possible that you need not to have a much physical space to keep your files, and the lawyers used to known by the SCC bookshelves behind themselves that books are filled. So you have all legal research analysis tools also. So right now we need not to have those books also. We just take the services of legal research tools like SCC Online and LexisNexis or Manupatra, which are available in India. So we can just log in and take a PDF copy of those judgments with ourselves. And even some judges also prefer if we can mail it them, those judgment compilations to them. So yeah, research, drafting, and these are some important tools, research tools. And also I would like to add the calendaring tool. Yeah, you have to my chamber uses a Google Calendar. We don't maintain as such a legal diary. Lawyers still carry the legal diaries or the diaries to maintain their case status and everything, that what is the next date for the next matter. But yes, now we are using Google Calendars and other calendaring tools also. So this is the preparation part. Many chambers have brought in their regular practice. Mr. Choudhary, would you like to add on this part also anything your chamber or you have seen, noticed that in the case of litigation preparation and presentations, things have changed and they have brought positive changes?
My experience, the post-COVID is a mix of it. If we talk about High Court and the Supreme Court, or for that matter, the NCLT, DRT, yes, digitalization has taken place to the great extent. And we lawyers had the privilege of appearing in these courts even from home. Even the filing was required to be done from home online. So those facilities were there. And I was the privileged lawyer who had spent most of my time even at my farm, doing the farming and doing the advocacy both together. But at the same time, you need to look into the different prospect also. The different perspective, when I'm saying the district courts, the lower courts, I live in Mumbai, predominantly I practice in Bombay High Court and Bombay City Civil Court, or for that matter, the NCLT and DRTs. But when the matters, being a full service law firm, we also have the matters at downtown and the rural areas. So when the matters were there, let's say even 50 kilometers away from Mumbai, let's say Panvel Court, I have experience of, network was down, things were not taking in place, the matter is not being listed. It is a very frustrating situation. Reason is being that sometimes the client comes to you with the immediate relief, some sort of injunction is required, somebody is required to be, protect his rights towards his property, and he has the risk of getting evicted from the property. Now, the matter was not getting listed, the judges were not available, online things were not working. It is very frustrating, and it's more than the lawyer, it was for the client who have suffered the most. Let me tell you, we being sitting in the urban area might be seeing things very positively, that things have done well. The Supreme Court has adapted the situation according to the time. High Court was not the different. Most of the High Courts have adapted, and I have all praise for them. But at the same time, we also need to appreciate the infrastructure level, the digitization level, the technology level down the line is not so great in the country like India. And not only the lawyers, those who are not getting the matters, you must realize hundreds of lawyers have attempted suicide and have done suicide in India during the lockdown because they are not getting the matters, because they were practicing in the lower court, and the lower court has no digitalization system, no video conferencing system. They were not getting any earning, and their bread and butter were at the stake. So my take on this digitalization is a two-way. Yes, it was good for the digitalization, it was good for the High Court and the Supreme Court, and so on, some of the courts like the NCLT and DRT. But at the same time, at the lower level, at the downtown level, at the rural level, where we have the magistrate court or the local judges court, senior division court, junior division court, it was a very frustrating situation. Things are absolutely not perfect. Things are very, very bad. Our hundreds of advocates have done the suicides because they had no earning on those periods. And really, the legal fraternity as well as the government need to do something on very urgent basis, on very immediate basis, that the infrastructure is developed and those courts are also have the privilege of digitalization. Thereby our fellow lawyers continue to practice and continue to earn their bread and butter and are not succumb to attempt such kind of the suicide.
So I come to Mr. Balakrishnan in this part. Since you were saying, I also agree that digitalization has made the things easy. You said it's a great, and Indian courts have adopted. But as Mr. Choudhary also mentioned, it's one of the dark part of this digitalization. And our current CJI also said in one of the sessions he took was with the NLUs, that we need to recognize this existence of digital divide and steps to bridge that gap, because some lawyers in district courts and even some lawyers who are not techno-savvy, they are not able to adapt this system and not getting that much earning or cases which were they getting. So what's your take on that?
Yeah, I think, 2, 3 things, I want to say. On a lighter note, I will start, when when you said about the books, now not being carried, and even today when we are virtually appearing, and I make a virtual background so that, it is seen that I have a lot of books on the backside, and, the shelf is filled with AAR and, England Law Report and, all kinds of things. So, the judge may get impressed and say, okay, this man has got a good practice, and, that's why he's spending so much of on those books. Leave apart, what Mr. Choudhary said, and I'm not denying the fact. Because it's a fact that, as far as India is concerned, there are a lot of people who are averse to technology. But I have my own doubt, because if you look at the global perspective, correct me if I'm wrong, is that, it is the Indians who have the highest number of mobile phones and mobile users in anywhere in the world, Because if you go to UK or USA, they buy a phone and, that phone remains with them for 10 years or 12 years, But whereas I'm concerned in, at least, I'm saying about Mumbai and the southern part from where my roots are there. If today, on November 2022, I purchased a mobile phone, which is iPhone 13. And, next day I get an ad saying that, iPhone 14 Pro is coming. I'll just throw this out and I will go for the latest one. So we are into technology because the education, forget about the judicial system, the education for these entire during lockdown was done through the mode of online. And I don't think, any of the remote people said that, my education was denied because of the fact that, I couldn't have an online system where there. Yes, I'm not saying that, there was a problem with advocates who couldn't adapt to this, or who didn't have the money to invest into these tools, and and therefore it was even Supreme Court said that we have to make them an allowance, the bar councils have to pay them an allowance. That still remains. I'm not saying, but as you said, any change or transformation is something painful for all of us. We are all in the comfort level, and when you are asked to get out of the comfort level, we get pain, and we find negative holes in it. So it is a time, now this is the best time as far as Mr. Choudhary's comment is concerned. I'm not denying that fact, but the fact is that this is the time to say that, we are facing uncertainties and at any point of time it can repeat, and therefore, we have to find alternate solutions, and, we have to invest in these alternate solutions and equip ourselves with that, because one plus point is that, maybe for the urban area, or, maybe for advocates who are practicing mainly in Supreme Court or in High Court, is that, I can sit and attend to a Karnataka High Court, and the same day I can sit and attend to Kerala High Court, and I can sit and attend to Supreme Court, and I can get in to Bombay High Court at the same time. All I need is, 3 types of instruments, and I'll have to keep logged in, because when my case is called out, I do not know, so I can have the same thing. And it also gives me, I'm thinking of the positive sides, I repeat that I'm not denying this fact, but the positive side is that, I have an opportunity, I get an opportunity as I'm an advocate who is practicing only in High Court or, something, I get an opportunity to appear before the Supreme Court virtually. So that is the opportunity would not have been there for me if I had, the physical hearing was there, because, it's an expensive thing, I have to go there and, I have to get all those things. So positive things are always there, and it's a realistic things, what he said is that, we have to, this is the time to change ourselves and equip ourselves, invest in ourselves, and say that, the pandemic is not that something which has happened only in 2020. Maybe in 2025 or 2026, something else may come where we all have to be shut down, and, we may have to see. And now today what happens is, companies are finding it difficult to bring people back to to their office, because we are used to sitting at home and working at home. And in the previous session, there was a question whether, is the law department, it is necessary to have a brick and mortar law department in any company when they can have all the tools. Digitalization can complete the law department. I would say that, they can sit in the comfort and, do it. So I think, while this is the best time to transform ourselves, equip ourselves, and become tech savvy, and look at the future and not look at what happens. See, what is happening is correct. So certain people are not in a position to get into the tools. But that something has to be done. The legal fraternity has to do something, and the bar councils has to do something, and give them training, and, give them the thing, and, go to the government and say that, we need much more better internet facilities in areas. And today, I'm coming from a banking system, because I was an in-house counsel in a bank. And, what happens is, banking system, we have been able to do financial inclusion. So everybody now, that is also now, our payment mode through UPI mode or Google Pay is now the best in India. So I think, this is the time we should change, we should equip ourselves and look at the future.
Mr. Adams, since we're discussing that bad part of technology, and Mr. Krishnan is the pro-technology person, so would you like to add some new angle to this digital divide? Because I also personally feel that some lawyers are not getting the cases because of this technology. But yes, would you like to add some angle to it?
I think in the Singapore bar, there isn't really much of a digital divide. We are a small country. Essentially, we have 100% internet coverage. So to do a hearing, what you really need is a mobile device which connects you to the internet. You need Microsoft Word to prepare your documents. You need Adobe Acrobat to convert them to PDF. And you need Zoom to log on to the hearing. So I think by and large, most of the Singapore firms have been able to adapt. Having said that, the Ministry of Law and the Law Society of Singapore have run courses. There are grants to help firms digitalize if they haven't already done so. And I actually think that digitalization has helped some of the smaller firms, because 10 years ago or even 5 years ago, if you have a case conference you need to attend, there'll be 40, 50 lawyers in the High Court waiting to attend cases, waiting sometimes 2-3 hours for your case to be heard. Now it's all done online. You can be in the office, you can be doing other work, and when it's your time for the hearing, you hop in, you get the hearing done, and then you hop out. And you can, I used to see cases where someone rushes from one court to another because they have a mentions here, and then they have a plead guilty somewhere else. And nowadays, that's just a lot easier. because of digitalization. But I think, yeah, by and large, people have been able to adapt. Because we are small, we may not have had some of the infrastructure difficulties that may have been faced in India. So, yeah.
I would like to take this session to the further question, which is the usual question. I would like to start with Mr. Adam only, since you last mentioned in your last comment also that since we know technology is a little cost effective also, and it has done the paperless things for in the litigation also. So can this digital system completely substitute the physical hearings? Can we think about that?
In my view, I hope not. I'm a trial lawyer, first and foremost, and I do think that for trials, many of the members of the Singapore Bar would prefer that witnesses are cross-examined in person, especially for criminal cases where liberty is at stake. If an accusation is made by someone, then I think that person should come to court. And of course, people can. I did about 20 over days of trial virtually last year, and the witness's face is on the screen. Every frown, every side glance, every furrowed brow is there for the judge to see. You can't run. But I do think there is a difference to a witness dialing in from home or from a lawyer's office as opposed to a witness coming to court, being sworn in court, and then giving evidence in court. So I do feel that for interlocutory applications, yes, going digital, doing it virtually makes a lot of sense. Certainly for procedural applications or procedural matters, case conferences, I do think it just saves everyone so much time to have it done virtually without having to go down to court and wait. But I do think that as far as trials are concerned, by and large, if possible, if it's not too difficult, I think it would be good for witnesses to come to court and to be cross-examined in court. Of course, others may have a different view, but having done that for 15 years, I would hope that it continues.
At least I also criminal litigation, I also agree that for the evidence and cross-examination, it's the physical courts are required. I have also the same view. So, Mr. Choudhary, as you mentioned last also that for some courts it is, yes, digital is helping. So, would you like to highlight that what kind of cases can still continue and that will ultimately help the lawyers also and the judges also in fast disposal of the cases? Or so would you like to highlight what kind of cases we can still?
No, the first thing that I'm not against the digitalization. My firm particularly have invested a lot in the digitalization, and we have been using the best of the technology that is available within the country. We are the one who are, as Mr. Balakrishnan has said, he was a banking counsel, he will understand, and we have been working mostly with most of the bank in India, whether a multinational, the national, the private sector bank, and the nationalized bank, and the most of the part of our work has already been digitalized. So it's not that we are not using digitalization, we are taking that opportunity, adapting that situation and using it wherever necessary. Now, coming to the litigation part of the digitalization, as I have said earlier also, the digitalization is possible at the superior court in the urban areas, like in the Supreme Court, the High Court, the NCLT, the DRT, some of the other tribunals like the SAT, but wherever the human intervention is necessary. Very recently, even the CJI, the Chief Justice of our country, India, Mr. Chandrachud has already said in one of the seminar that we cannot completely, do away as far the physical hearing is concerned. Yes, to the great extent, we need to adapt the technology. The technology not only will help the advocates, but it also helps the litigants to the great extent. Reason you understand when the matter goes like from the Bombay High Court, suppose we are filing SLP in Supreme Court, we need to travel over there. And then sometime it happens, the judges is on leave, judges has some, the chamber work, and then the client has to again extend the, the hotel charges, the flight charges, your stay charges. So it is, you need to understand from the client perspective also. The client has to spend a lot of money, a lot of time and energy has been wasted of the lawyers. So digitalization will certainly is going to help us as far as the superior court is concerned, especially the matter where the corporate litigation is involved with, like for that matter, the NCLT court is concerned, I think it can be, to the great extent, it can be digitalized. The DRTs are concerned to some extent, yes. High Court and Supreme Court, the SAT court, these courts to the greater extent, but the courts like the consumer courts, the courts like the lower division and the senior division, at that level, digitalization is still a farce. We must realize and accept the ground reality that our country is not prepared to accept digitalization, not because of the mindset of the lawyer, not because the local lawyers are not ready to adapt the technology, but the fact is that the infrastructure of technology is not available at a grassroots level even now. When we talk about India, again, we talk about the India, we consider only the urban part of the India. The more you go to the ground level, the rural level, you realize, I don't want to mention about the farming part, but when I was at farm, most of my, the farm workers, their children, they were asked to come with a mobile phone. They were not having the mobile phone where they will buy 20,000 rupees, 18,000 rupees the mobile and then go and attend the, the classes because of the classroom was almost closed. It was all study from home. It's difficult. We need to realize those guys, those are earning 300, 400, 500 as a per day as a daily laborer, or as a farm workers, having 2 children or 3 children in the family, buying 40, 50,000 rupees for a smartphone, not easy. We may talk over here, the digitalization, as I said, yes, to the great extent, to the urban area, to the affluent people, yes, it is possible. We must do it. We must adopt it. I'm the one who is adopting it. I'm not against it. But at the ground level, at the rural level, it's still difficult. And therefore, I said, at the superior court, like the High Court or the Supreme Court or NCLT and these kind of the courts, yes, we need to have the major part of the digitalization, major part of the video conferencing. But as the CJI himself have said, it's completely cannot be done to some extent, let's say 30%, 40%, as you have been appearing for the criminal side, for the cross-examination and for the witnesses and all that. Of course, you need the physical presence. Unless the physical presence would be there, the many part of the criminal procedure cannot be completed without being accused or the witnesses present in the court and is available for the cross-examination and the testimony in the court. And therefore, these two systems will go around, will continue to be in the country. This is what my view is on the subject matter. Thanks.
Yeah, I think what I feel is that the appellate courts, that be it in High Court or the SLPs in Supreme Court, and be it anywhere else, it has to be in a digital mode, because the appellate courts, the question of law is most important rather than anything else, and the physical presence of everything. Yes, I do agree that in criminal courts, physical presence is most essential. As Adam said, what happens is that, when you are giving a statement, when you are being cross-examined, the body language is most important, so that a judge can see only when a physical presence is there. I'm not denying the fact that today for remand applications, I would say high-risky prisoners are made to present through the video conferencing, and then, that's only for a remand application. I think, Tushar knows much better because I'm not in the criminal side of practice. So it's a question which I want is that, the duality has to continue. Because what my fear is that, after the ebbing of the COVID, the courts now have a tendency to come back to the physical mode, though there is a filing of e-filing is there. See, for example, my major practice is in NCLT. When I'm filing it, e-filing is there, and with the e-filing challan, and I have to submit the physical copy also. And when the hearing is there, the costless says, physical copy not available. So when I'm arguing the case, he said, no, physical copy is not available, Mr. Gopalakrishnan. So yeah, we will post it for another day and you file the physical copy. So I feel a little frustrated or a little funny in that, then what's the use of my filing a online copy and then they say that physical copy has to be filed. And in certain cases, yes, NCLT is now functioning on online because of the fact that the members are less, and you have managed to manage a lot of benches. So from 11 to 12, they will sit in one bench, and 12 to another. So that may go because some new members have been selected. So what is that, there should be a clear demarcations as to what exactly has to be compulsorily put in the virtual mode. Unless there is a dictum from the courts, or from the High Court or Supreme Court, this is not going to sustain, because we will think only when another pandemic comes. Otherwise, what happens is we have to say that certain things will be taken up only in virtual and the other things in physical. Physical has to be there. I'm not denying criminality courts are concerned. Physical is there. And even in the NCLT, certain cases they will say, okay, we will have a physical hearing, and you fix 12 o'clock, you have to come here, and physical hearing is there. I have attended a lot of physical hearing, and the Bombay High Court has now completely gone into physical hearing. And as far as the judges are concerned, certain judges are very tech savvy, and they like to get things in by email, the judgments and everything. Certain judges are not so. So I think overall training is necessary for the judicial officers, and we have to compartmentalize and say that certain cases has to be heard only by virtual mode. Otherwise, this sustainability of this digitalization may not say, except for all the courts, including our Chief Justice says that everything has to be digitalized, but every filing has to be, every records has to be kept in a soft form or an e-form. That may happen, but the fact of the matter is that, sustainability, if it is to be there, we have to compartmentalize it and say what is going to be heard physical and what is not going to be. I mean, trust me, I'm not against physical hearing at all, because, see, that's not the impression that in a criminal court or, in certain big stake cases, physical hearing is necessary. But we have to begin it. We have had a leeway. Now we have to sustain that. For sustaining that, we have to compartmentalize it. You had a question, I think. Yeah.
Thank you, the panel. My question is more than the question, factual clarification on certain aspect. Within 6 months, the first lockdown in India, March to September 2020, 1.5 million cases were disposed of. So to say that, as Mr. Choudhary, I think, gave little bit portrayal of a negative side of the modern world of litigation due to digitalization, etc. I just want to clarify that up to the tehsil level, the lowest level, there are service centers available. Even I was just checking now at this moment, there are courts, district courts and session courts are also working through Zoom. I wanted to point out, because I myself have appeared in many matters up to that level, district court and all. Thank you very much.
That's a good thing that you came up with the facts and figures, because while Mr. Choudhary said is a fact, but the fact is that 1.5 million cases were disposed of during the 6 months period is something very heartening.
And lastly, I think Mr. Choudhary also pointed about this suicide and all by the lawyers. I must say that in all the profession, all these streams, it must have happened. The lawyers are the toughest and adaptable, most adaptable creatures of this entire world, I must say that. And it's not that easy. And even the government of India, all the bar councils have allowed and given the, compensation during that period. So it was not as that tough. They were also allowed to take up the other professions as well during this interim period.
Yes.
So, Mr. Choudhary, I'm so sorry to say, but the portrayal has to be correct based on the figures and facts. Thank you.
Thank you. Thank you.
Yes. So before we reaching the time of that. Afterwards, we'll take the question after the ending of the discussion, sir. So, Mr. Adam, would you like to add some other aspect which you think it needs to be brought before the audience here about this modern mode of litigation, which we haven't covered, or anything you want to?
No, I think in general, I agree. There's a place for virtual hearings, and there's also the need to maintain certain physical aspects. And I think the Singapore courts generally are following that. So as I said, appeals, interlocutory applications where witnesses are not involved, Generally, it's being done virtually, but as long as there's a witness involved who needs to be examined, then the courts are doing it physically. And I think across the panel, there seems to be some consensus that that's the right approach. So I'm hoping it will continue, and I think knowing the Singapore courts, they are likely to continue with this approach.
So if if I want to just summarize the session, then we can have a questions. So after the comments and views of all the panelists, so according to me, I guess hybrid is the answer, which many courts have adopted. That because I personally see in many courts that you have an option either to appear through virtual mode or the physical mode is going on. So yes, technology cannot be the complete substitute, and the hybrid things, and basically the nature of the case has to be seen, that whether it can be digitally taken or not. Like the NI digital courts and negotiable instrument courts are completely digital in some states. So that's good, that leads to faster disposal. And maybe the arbitrations, people sitting on different parts of the world or city or the same country, so they can connect virtually. So yes, I guess hybrid system should continue, technology should adopt, and the judiciary and the government which are thinking in this manner. So I would agree with one of the comments which were made by the judiciary and governments are saying that the technology must be the facilitator of this change. Yes, definitely. But yes, some human element has to be there. So the driver of that change can be the human mind. But yes, technology and human mind both have to work in sync to lead to the great success. So with this comment, I would like to summarize. Now we can have some questions. Yes, sir, please. Can you, Bharti, give the mic to
It's a question for the panel. How much are you in favor of broadcast of court proceedings? I know that Odisha and Gujarat have started this. Would this, and the following up question is that, would this ultimately look into the accounting aspect of a lawyer too? Because this is modern litigation, right?
Yeah.
I mean,
no, I'm all in for broadcasting, and unless otherwise, see what happens is, certain issues.
no, not all. Not all.
Yeah, not all. Then I have no issues, but it is good for the clients also. I'm looking at from the other side, because the lawyers will come prepared, because they know that I can't go and say that it's like take it lightly only. We go to the court, and the court has not heard my case, or the other side is asking for time. So when I come back to the office and when I send an email to the client, what will I write? I'll write, the case was posted on board and today, and the opposite party asked for time, but we vehemently objected it, and therefore ultimately the case is now posted to January 2023. So that vehemently opposed will not be written by me, because of the fact that the client is watching. The client can know whether I've come prepared or not. So that's a good thing for the client. And also it's it will I'll be sharpening my skills, my skills to come to the court, because I know somebody is watching me. It is like a CCTV camera watching me. It says that under surveillance, and therefore I'm being watched. That is good thing.
So what about the Singapore perspective?
Singapore has a sort of a hybrid approach. If the matter would have been an open court matter, for example, the trial, but is being held virtually, it won't be broadcast to the world at large, but it will be broadcast in a courtroom. So any member of the public can go down and watch it if you want to. But for matters which were normally private, in chambers, those are not broadcast, and it's strictly only the counsel. And if you want a client representative to be present, you need to make an application, and it can be done in certain cases. But generally, there's no further extent or greater extent of broadcasting than there was before digitalization.
Thank you.
I would just like to add to your thing also, and even for the thing, it depends certainly on the cases to cases, like in cases in district courts where the private disputes or some criminalities involved, so people would like to have that case broadcasted. But yes, sometimes the issues like the privacy and Aadhaar cards, or the NJAC appointment new question have been written. So these are the public issues where the general public who does not have an access to the courts, they cannot normally enter if they are not a party to it. So like last Chief Justice has started live streaming of the constitutional bench matters. So it's a good start to do it with.
Somewhere we'll have to balance between the transparency and the privacy. You know, what we're talking about, the transparency, then of course this needed to be broadcasted. But at the same time, needed to be with the caution, with the care, so that the privacy is also maintained. So both are equally important and both should run away together.
No, I think it will end. One more thing is that, in very important public interest litigation or something like that, where, channels write their view when the case is heard, today the court asked this question, that questions, so we will come to know the truth if it is live stream. Otherwise channels will write, we are the first to bring in this, you're the first to bring in. And I also go a step further and say that, big criminal cases where physical trial is happening, that can also be live streamed, because that will give the public, as to understand what exactly is the court doing in such cases. Because everybody, when the court decides on something, if it's a very big murder case and ultimately is acquitted, then the people will blame it on the police investigation, or people will blame it on the public prosecutor, or people will blame it on many things, on the judge also. So if it is live streaming is there, we will come to understand what are what was the reason and what is it that in a criminal case what is needed. I feel that is something very good. And first and foremost is that it will prevent these channels to publish sensitive news, which is completely destroys the fabric of the case, and that's it.
We need to thought about the media trial in that. That's
Media.
It. Any other question? Okay. Thank you for the patient listening, and thank you so much.
Thanks.
Thank you to all of you.
Thank you to all panelists.